Good afternoon, everybody. Thanks for joining us here at our breakout session. My name is Tutaj. I'm from the law firm of Meissner Tierney Fisher Nichols. I'm joined with a number of my colleagues today, and we're going to be discussing the subject of raising outside capital, particularly important topic in a time frame where banks are getting distressed and lending can become dear. When businesses, small and closed-out businesses, need to raise additional capital, the need to take on outside investors can become current choice. I'll be beginning our discussion by kind of going through a high-level overview of the operational and organizational documents you'll need to think about and the provisions that you're going to need to consider adopting now that you have outside players involved and outside owners. I'm going to turn this over to my colleague James Sosnoski, one of our litigators, who will talk about some of the consequences of getting some of this stuff wrong. It's a lot less pleasant topic, but that's litigation generally, not James specifically. And then followed by Randy Brotherhood and Mark Hamilton, who are going to take us through the actual rules and regs and mechanics of going about and making that ask and raising that money, because you are dealing when you're dealing with essentially securities when you're selling interests in a going concern business, and while you may not be publicly traded, there are rules and regs and consequences that attach and things you have to do. So we'll begin the topic here with considerations when you're going to take on outside equity owners. As was alluded to a lot of times during the plenary discussion, in a lot of family businesses and small and close-held businesses, it can sometimes be a one-man shop, one-woman shop, and what the owner says goes. And in that respect, the bylaws, the articles are kind of ornamental. A lot of those formalities aren't followed. But once you start taking on cash from investors, they take on a whole new moment, and those documents become enforceable. There are contracts and there are obligations that people seek to pursue those rights. Additionally, when outside investors are bringing cash, if they're not going to be in control in some major respect, and that's usually the case, they're not going to be buying 100% or even over 50% a lot of times, they're going to want to have certain inputs and protections for their investment. So one of the first topics that comes up is the question of voting rights and what sort of say will they have in the day-to-day running of the company. And this usually takes the form of having some input into who some or all of the directors and managers of the company will be. May not be a controlling stake in the board, but maybe they just want to have one seat on the board, which will allow them to have access to all the sort of day-to-day operational information. And the bylaws or operating agreement or shareholder agreement will usually make some provision for who's going to have a say in getting appointed to those board seats. Short of being on the board itself, just by virtue of being an owner, a shareholder, a member, certain extraordinary transactions they may want approval rights for. Some are built into the statutes, like mergers, sale of substantial assets, but a lot of times investors may want to negotiate for something bigger transactions that fall short of a major sale. For example, expenditures over a certain dollar amount, or certain maybe even hiring and firing decisions, the kinds of things you might see as negative or positive covenants under a loan agreement. Because again, they're not lenders, but they put in substantial money at risk. They're going to want to say on big things to make sure that those rights are protected. After the subject of voting rights will become the question of some of the economics, distributions. And those usually take two forms. There's the actual kind of ongoing, what we call non-liquidating distributions. If investors are not working there, they're not getting a wage, they're not getting compensation. So it really comes down to what are their dividends? What are their how do they get to withdraw some of the profits out of the firm short of the sale? So we call those non-liquidating distributions. And then there's the liquidation distributions. What do we get when we actually sell the business or sell the concern? And the big issue that will come up with investors is, do you give them a preference or not? And by that we mean, they've now put in this outside capital. Are they going to be just even Stevens with everybody else, right? If they own 20%, they get their 20% as and when each bit comes out? Or do they get a preference, meaning they get their first, they get their 20% back first before other people. And that's going to be something that's going to be a topic of negotiation. Apart from the management and the economics and distribution rights, another very important topic is information rights. By statute, shareholders and members have access to a certain level of financial information from a firm that they can request. It's particularly important when you're dealing with a partnership or an S corp, where some of those, the actual economics find their way onto your personal tax return. You've got an interest in understanding what's coming your way. So it's not uncommon to want to get an entire copy of, say, the tax return or financials. It's just shut down. Okay. All right. Thought I'd got to
Let me
shut off here.
No, don't.
All set? All right. Good.
Technical difficulty.
Sorry about that. Under the statutes, though, apart from the minimum rights you have, you can expand that set of rights. And so the investor, not unlike the lender, may say, I want to see quarterly financials, I want to see monthly financials, I want to see bank statements. You may not want to give that level of information. That's going to have to be negotiated largely based on how big their investment is and how important they are. A certain, smaller tranche investor, you may not want them having really expansive rights to see, every little thing. And in some cases, you may even be aware that they've got competing interests. And so under the statutes as well, you're allowed to include certain protections. For example, you need to have a proper purpose to be getting that level of detail, or I want a confidentiality agreement before I give you that level of detail. Certainly true in the publicly traded space, just because I own, a share of coal stock doesn't mean I get to go in and say, hey, show me all your books, show me your purchase order, show me everything. No, that's not how, you're only entitled to that level of information that the organizational documents or the statutes permits. So that's going to be a topic of, again, much negotiation with people looking to protect their investments. The next topic is dissenters' rights. That's a term that basically means give me an exit because I didn't have a voice here. I didn't like this transaction. I don't want to do this deal. I think this is a dumb idea. Buy me out. And we get into the question of, what do we buy you out at? What sort of value? Do we apply discounts? So that whole set of mechanics essentially is to say, if you're not going to let me have a say, or you're going to do something I don't want, I want to veto with my pocketbook here. Buy me out. Rights of first refusal could be particularly of importance when somebody's buying a certain stake, a certain percentage that's going to assure them certain rights. Let's say they bought 25, 30%, and they know that certain approvals require more than, say 75 or 80. They don't want to get diluted. They don't want to get liquidated. They don't want more shares going out the door, or they don't want other groups, accumulating more interest. And so a lot of times there'll be a provision that says, if you're going to start issuing new rounds of capital, or there's going to be any kind of sale of shares between and among the members, you've got to give some or all the other shareholders essentially right of first refusal to buy those shares, buy those interests, and preserve their percentage. Buy-sell provisions, so short of things like the dissenter's rights, there just may be natural times where it's appropriate for somebody to exit. It's particularly true in service businesses where somebody's not working there anymore, if they're not a partner, if they're not actually contributing their services, that may be the appropriate time to say we're going to force a sale, or we're going to give somebody an option to buy or sell the other one out. Death or disability are also common events, and you might also just put some sort of deadline or time frame. Not uncommon in some sort of roll-up or PE type transactions where certain events don't happen within, say, 5 or 7 years of an event. Okay, we're going to engage certain options to be bought out or buy somebody out. Similar topic is one, you may have heard this term before, called tag-along and drag-along rights. So if I'm buying into a firm and I only own 20% of it, and I can't veto a transaction, I may not be able to stop the company from being sold. And I may not be able to stop my 80% partner from selling his entire interest to somebody else. Now I'm saddled with some other guy that I didn't know or like or trust that's now owns 80%. So to protect some of those interests, we have the one version is called the tag-along right, which is if I'm the minority and that controlling shareholder is selling his interest, I get the right to tag along. They have to buy me out too at the same terms, because I don't want to be stuck with this new person. And the drag along is the equivalent of, okay, I'm the controlling party, I want to get out of here, but this buyer wants to buy the whole thing. I shouldn't let this 20%er bollocks up this transaction and prevent me from selling, so I get to drag them along on the same terms. So that's, again, a very commonly negotiated provision when dealing with minority investors. And then lastly is the topic of registration rights. This will become a little more, gets a little more into the securities law weeds of things, but especially when a firm is either going to go public or is anticipating to go public, you may find that certain classes of shares are what we call restricted, meaning they're not public, they're not registered, they're sort of off the books, and if you're part of that investor class, you may want to make sure that you've got the right to have those shares registered later so that you do have an exit. You can go out in the market. You also can get out and get cash. So each of these, can get into, dozens and dozens of pages of text in the documents, but these are the kind of main negotiating points that you're going to have to reckon with when dealing with particularly an outside investor. It's certainly true, it could come up in the family setting, but in many of the small and closely held, again, it tends to be a lot less formality, a lot more levels of trust and handshaking that happen. Nothing wrong with that, but that works till it doesn't. These are the things you want to get in writing if you want to protect that investment. I'm going to turn things over now to James, who's going to talk a little bit about what happens when we don't protect those things.
Sure. So thanks for coming out here today. My name is James Sosnoski, as Adam said. I'm a little different than Adam, Randy, and Mark here in that I'm a litigator. These are the guys that you call to kind of set up these transactions, paper everything up. But I'm the guy that you call when something goes wrong. And so as Adam talked about previously, you're introducing new people into the equation who have their own interests, who might get into disputes with you. And as Randy and Mark are going to talk about a little bit, there's a lot of very kind of technical legal requirements you've got to follow, particularly with respect to securities regulation. And so one of the biggest risks you run if you don't do this correctly is litigation. You're having to call a guy like me. Now, a good litigator is very, very crucial if something does go wrong, but anyone who's been in litigation will tell you it gets expensive very quickly. You're paying lawyers to do discovery, to respond to complaints, and you obviously want to avoid that. And in the context of raising capital, in this way with like a private placement, there's additional concerns that come into play, because when you are raising money, essentially selling equity in your company to people who are not going to be actively involved, you're probably selling a security, right? Securities are something that Randy's going to talk about in much more detail than me, but that does expose you to claims like securities fraud. If there's a claim that there's a misrepresentation or omission of material information in the offer of the purchase or sale of security, you can be subject to federal Rule 10b-5 claims, state law counterparts under blue sky laws, and that's just a whole mess that obviously nobody wants to be involved in. So, what does that look like? On the one hand, you can certainly be subject to a claim for damages, the damages caused by any kind of snafu or misrepresentation. But there are also additional remedies under federal securities law. In particular, one of the most notable here is rescission of the transaction. So that means undoing this transaction that you worked so hard to put together. If somebody comes back and claims rescission and is successful, now you've got to take that security back, that equity that you just sold, and pay them back their money. Plus, now you're out all of the fees that it took to defend the claim. So I can't stress this enough as a litigator. You really want to structure these properly on the front end. Having guys like Adam, Randy, and Mark working on it who are going to take the care are going to save you from ever having to call me. So that's really some of the main things. There's additional federal regulations that might kick in. You might get a federal or state regulator looking at you depending on the claim. But the big thing here again is you might get involved in litigation. Particularly securities litigation, and Yeah, you don't want to have to call somebody like me, but I don't want to take up too much time because this is mostly about how to raise capital. So I think at this point I'm going to turn it over to Randy.
All right. Thank you, James. This is a part of the program where I feel like I'm administering castor oil to the audience because it has to do with all the restrictions and things that you can't do or have to be restricted in doing and in order to issue securities. So my name is Randy, Brotherhood, as Adam and James pointed out, and I'm here with Mark Hamilton, and we're going to talk for a few minutes about the legal and regulatory considerations of obtaining capital with particular reference to the issuance of securities to investors. And when I refer to securities, I'm of course referring to instruments commonly understood by all of us to be securities, such as securities in an equity setting, or notes or bonds in a debt setting. But I'm also referring to instruments that might not be so easily identified as securities. And we'll talk about what constitutes a security in a few minutes. And we're also going to talk a little bit, or I should say Mark is going to talk about the notion of crowdfunding as a new vehicle for issuing securities in Wisconsin. I should say it's not entirely new. It's been around for a while, but it's still relatively new in terms of issuers and companies getting used to the notion that it's there as a tool. I'm going to be talking really fast because there's a lot of detail, of course, involved in any type of securities regulation setting, but I'm hopefully going to have time to touch on the important concepts and give you a few takeaways so you can get a handle on the essentials and get a rough picture as a starting point. Try to move there we go. So as a starting point, let's begin with the notion that a business seeking to raise capital in Wisconsin from investors must consider carefully the securities laws at both the federal and the state levels when determining how to structure a fundraising transaction. At the federal level, there are a number of important statutes, but the primary one is a behemoth called the Securities Act of 1933. And your lawyer will know what that is if you ever take a fundraising transaction to him or her. And it sets forth the requirements for either registering securities, which is the default, or finding an exemption from registration. And then each of the 50 states and the District of Columbia also have their own state securities laws that I won't say mirror the federal statute, but correspond closely to it in the sense that almost all of them provide, again, for the default of having to register a securities offering before you go out to seek investors, or you have to find an exemption from registration. And of course, each of these statutes have a myriad of regulations under them that, again, a securities lawyer will be familiar with. And then if you're, let's say, we're all in Wisconsin, and you're seeking from Wisconsin as an issuer to obtain investors outside of Wisconsin, you also have to consider the laws of any state in which the investor is located to determine whether there's an exemption from registration and offering securities to that investor in that particular state. And truthfully, that can become a little bit unwieldy if you're going to be seeking investors in a large number of states. We lawyers do something called a blue sky survey if it gets to that point, and essentially it's a report that describes what the requirements are in each of the states. But by and large, if you're focusing primarily on Wisconsin, or maybe just a couple of states neighboring Wisconsin, it's a pretty manageable task. Let's see. So, move back a little bit. So both the federal 1933 Act and the Wisconsin Securities Act deal with, as I say, the offer, the sale, and the issuance of securities. And the approach at both the federal and the Wisconsin level is based on a policy of what the law calls full and fair disclosure, the notion that all material facts should be accurately and fully disclosed to potential investors, and then after that is sort of let the buyer beware. But there are specific requirements in terms of what constitutes full and fair disclosure in certain contexts. In a registered offering, very detailed disclosure requirements are specified. For some exemptions from registration, there are also specific disclosure requirements. And for other exemptions, there is just the notion of your subjective determination of what constitutes full and fair disclosure. But the essential regime, as I indicated, both the federal and state level, is you either have to register your securities, which is a major undertaking reserved only really for large situations where the traffic will bear the cost, or you have to find an exemption from registration. There's no third option, registration or exemption. For most practical purposes, people in this room, we're talking about finding an exemption from registration, and I will tell you that by and large, that can be done in most settings. But I want to focus on exemptions in the rest of this presentation. But it's important to note that even if you have an exemption from registration, you still are subject to the anti-fraud provisions that James mentioned, to the securities laws and this requirement of full and fair disclosure, whatever it means in a particular setting. So I want to talk for just a minute about what a security is, because sometimes, most of the time, you will have a security, but there are some cases in which you don't have a security. So I want to talk about that for a minute. Both the 33 Act at the federal level and the Wisconsin Uniform Securities Law has very detailed definitions, I should say pretty detailed definitions of what a security is. And Wisconsin actually has one of the more refined definitions of all of the state laws. And it includes certain specific things. It actually specifically includes limited liability company interests and limited partnership interests, which over the years, since, for instance, the limited liability statute was created back in the early 90s, there was actually a question as to whether or not an LLC interest was a security. That's been resolved. It's specifically stated in the statute in Wisconsin. And there is also the notion of an investment contract being a security. But by and large, at the federal level and at the state level, there is a test that's set out that basically helps you determine whether you have a security. And Adam pointed to it earlier. It basically is a test that involves determining whether or not you're offering an investment in a common enterprise with an expectation of profits derived from the essential managerial efforts of others. So essentially, if you're offering a security to an investor, and that investor is not going to be involved in the business, but is essentially giving you funds with an expectation that he or she will make money, have a rate of return from having given you that money, you've got a security. And that's the essential of the definition. In some settings, if a party is giving you money and they don't, let's say they have a donative intent, they intend to give you the money, let's say a parent or a friend or a family member, and they have no expectation of profit and are not expecting to be repaid, it's possible you could find that there isn't a security and you're outside of the securities regulation regime. In a setting where two people are starting a business, or one is starting a business and they're bringing another in, and that person's going to be actively involved as a partner every day, as an employee, as a co-venturer, it's possible you could find that there's not a security. But anytime somebody's giving you money, and the more people you go out and try to find to fund your venture, the greater the likelihood that you're going to have a security and a securities offering with respect to which the securities regulations apply. So against that conceptual framework, you should consider in your setting, when you go out seeking funds, do I have a security that's subject to securities regulation? By and large, the answer will be yes, if you're going out looking for relatively passive investors who won't be actively involved in the business. So I want to turn just for a minute to the issue of how to analyze whether a particular exemption from the federal and state registration will be found. And as I said earlier, the good news is that for the most part, most parties will find an exemption from registration. Some of them have requirements attached to them, and others have are what we call self-executing. They don't have any particular requirements attached to them. If you qualify, you're in it, and you can proceed. Both the 33 Act and the Wisconsin Uniform Securities Act exempt from registration certain types of securities. And there are also what we call transaction exemptions. By and large, securities exemptions are limited to situations like bank securities or insurance securities, and really for our purpose are really not part of the equation. So basically, closely held businesses are going to look for a transaction exemption. Is there a particular type of transaction exempt from registration? At the federal level, the core exemption is what we call the 4A2 exemption. It refers to an exemption under the Federal Securities Act, which basically provides that any transaction other than a public offering and a private offering is exempt. It's a subjective standard to determine whether you're under it. And again, in a very small setting where you're going out to get one investor or two investors, sometimes you can basically determine subjectively, well, I don't have to worry about at the federal level there being a public offering. But the general factors that are considered are in determining whether or not a offering fits within the private offering definition has to do with the sophistication of the investors. Are they well-heeled? Do they understand finance? The law calls those accredited investors. Generally speaking, they're people who understand finance, who have a net worth of at least $1 million. It's not a super high bar, and $200,000 of annual income. Another factor is, do investors have access to information? And this is where the notion of full and fair disclosure could come into play. The smaller the number of investors you're going after, generally speaking, the less that calls for the conclusion that you've got a public offering as to a private offering. So if you're only going for a very small number, that's a good sign from the standpoint of an exemption. Those are the types of factors that you would consider subjectively. Now, a lot of issuers, particularly when you start getting close to the glass on some of these factors, don't want to rely on a subjective determination. And the federal law has an exemption called Regulation D, which is a safe harbor exemption. If you fit within one of the rules of federal Regulation D, by and large, you can safely conclude you've got an exemption. And if you take away just one thing from the presentation today that I'm providing to you here in a way of information, remember Reg D, because while it's relatively complicated, lawyers understand it who deal in this area, and if you can fit with one of its three exemptions, by and large, you can relatively safely conclude that your offering is exempt. You're still subject to anti-fraud standards, as James has pointed out, but you can at least say that you've got an exemption from registration. And there's an interplay between the three exemptions of Reg D, between number of investors, the nature of the investors, how you offer the securities, that kind of a thing. And I don't have time to go into each of the rules, but by and large, most closely held businesses can find an exemption within Reg D that fits their situation. How long do we need time? 10 minutes. I'm sorry? 10 minutes. Okay, very good. Okay. So, as I say, Reg D is an exemption you really want to remember. There are other federal exemptions that, if you have only accredited investors in your offering, that's one exemption. At the federal level, there's an interstate exemption that says that if you're only offering to investors in one state, you've got an exemption at the federal level, and that kind of a thing. Now, there are also exemptions at the state level, and by and large, I won't say they mirror the federal exemptions, but they correspond to some extent. There are exemptions for limited number of offerees. There are exemptions for that pertain only to accredited investors. There's something called a federal covered exemption as well, which means that certain listed securities that fit within the definition of a federal covered security are ipso facto exempt at the state level and preempted from regulation by the states, other than the state is allowed to require a filing fee or a notice filing or something like that, but they can't substantively regulate them. And here I come back to federal regulation D. If you can find an exemption at the federal level under Reg D, particularly Rule 506, I'm not going to get too much into the weeds because we don't have time. That's considered a federal covered security at the state level, and the state is essentially preempted from regulating it, other than requiring notice filings and that kind of thing. And that's pretty perfunctory. So again, I commend you Regulation D, in particular Rule 506, because it provides for a pathway to probably the simplest possible regulatory situation for yourself. There are other state exemptions, but those state exemptions can be regulated by the states on a merit or substantive basis. And for my part, I don't consider them to be as desirable, but they're there if you need them. If you're only dealing, as I say, with accredited investors, a limited number of offerees, that kind of a thing, you are able to avail yourself of those exemptions. I could go on, but I want to leave Mark some time. Crowdfunding, as I say, is a relatively recently added exemption at the federal and state level. There is more and more experience being had with it, and Mark's going to tell you a little bit about it.
Yeah, if you want to pass it to them. So as Randy mentioned, there's a lot to go over with respect to raising capital and relative security exemptions that exist. So we'll pull up kind of the 4 different realms of crowdfunding. I'll specifically be focusing on equity crowdfunding overall, but by and large there are 4 different pieces to keep in mind here. The first being equity crowdfunding, which basically allows a small business or business in general, typically a startup along those lines. Is the mic not on? No, it's not. There we go. Does that sound better? Awesome. So basically there are 4 types of crowdfunding, first being equity crowdfunding. And as I mentioned, this is a form for a small business, a startup, or a closely held business or something along those lines that can basically provide a portion of the business in exchange for funding or an investment. You'll then have debt crowdfunding. Debt crowdfunding operates as a peer-to-peer lending. I believe an example would be like Lending Club, for instance, which is more or less like an interest attached to a loan. And then you have things such as rewards crowdfunding. I'm sure you've heard of this on either watching Shark Tank or something along those lines, where there's things such as Kickstarter. The idea here is we have a product, a business, whatever it may be, and we have a specific amount we're trying to reach. And if we raise that amount, then to disperse the funds, the investments then go to the startup. And in that situation, the reason it's a reward system, or reward crowdfunding, is because those who chose to invest are getting some sort of incentive out of it. And instead of it being equity, for instance, you're getting a special product, a special edition, something along those lines. And then the last being donation crowdfunding, which is, Randy mentioned, this is the idea of just someone basically giving you money for your business, or just giving you a donation, more or less, just quite literally a donation. So there's 2 realms here to consider when it comes to equity crowdfunding, one being the federal law and one being Wisconsin specific. I'll focus more on Wisconsin just so I can kind of go through some of the necessary steps that you have to go through if you want to consider making an offering being the equity crowdfunding process itself. So first thing that you would have to do is basically state that there's a notice of claim of exemption under the crowdfunding exemption, which more or less you're basically stating that you do meet this exemption. And then once you do that, you basically have to go through a separate level of steps, being you have to come up with a disclosure statement. Your disclosure statement is basically stating what your business does, what the type of business, your directors. It could include terms and conditions for the securities being offered and things along those lines. The whole point of this disclosure statement is whenever you have an investor or someone who is seeking to invest in your business, you essentially have to give this disclosure statement to those investors. So that way they're privy to what exactly it is that the business is doing, what they're trying to raise the capital for, and ultimately the goals for not just the business temporarily, but kind of a general scope of what exactly the business is doing. On top of that, you have to have something called an escrow agreement, which this is more or less kind of serving to safeguard the investor here, not just the business, because the funds that the investor chooses to invest, whatever amount it may be, will be held in escrow, and that's done until you reach the amount that you're choosing to raise, and that again would be specified in your disclosure statement. So this also kind of builds a nice relationship between investor and business, because if you don't reach your total by the specified date that you mentioned on your disclosure statement, your investor can then choose what to do with those funds that are being held in escrow. So it kind of has a nice way to build your relationship there between both parties. So to kind of give you a way to see this overall, just kind of a general view and graph of how this works, you'll essentially have you being the issuer of the business or whatever it may be, and you operate through a funding portal or an intermediary. So think of this as basically when Wisconsin's called an internet site operator. So think of like a forum or something along those lines that houses all of the information that you had to upload. So your disclosure statement, escrow agreement, all of that is essentially housed in for view of a potential investor. So they'll find that through the internet site operators. There are multiple here that are specifically registered within Wisconsin. Think like Craft Fund LLC. If you've ever heard of like Mob Craft Beer, things along those lines, that's kind of how all of it ties together through this intermediary. And once you see, once an investor kind of contacts you through the internet site operator, they can have access to all of this information. That then allows them to choose if they want to invest based off of what they're reading for your business or your startup or whatever your idea may be. And then at that point, the escrow agreement kicks in, where if they do choose to invest, the money will then be held in escrow. And on the left here, these are just the regulators, being the Securities and Exchange Commission, DFI, and then FINRA, who kind of operate with the respective realms. So if we're talking about Wisconsin specifically, it would be DFI. But if you're doing something more akin focused to like federal law, then that's when the other two would kick in more so than just specifically DFI in Wisconsin. So just kind of a general view of everything I've kind of spoken about here is equity crowdfunding operates mostly as a security-based form of crowdfunding, where securities are issued to the public in exchange for the investment. I've stated a few benefits, but I think the key three are specifically quick access to capital. Once you go through the process to show that you have the notice claim of exemption for crowdfunding and you provide the requisite information that is needed, this allows you to immediately open yourself up, depending on what you specify as your end goal in the disclosure statement, to have access to this capital. Two, I think it allows you to have foster a beneficial relationship with investors, not just the investor who chooses to invest, but in general, investors by and large, because now you're being a little bit more transparent with what it is you're looking for and what it is you are offering specifically as the business. And it kind of allows for a nice interplay between both investor and business. And then three, the ease of access and use. Everything is done through the internet site operator. It is all posted there. Once you essentially play your part as the business, the investor can find it all in one portion or one spot, being the form that exists for the intermediary. And so it allows for a streamlined process to go through.
Well, thanks Mark for that.
I was just going to say that the crowdfunding exemption ought to be compared to the Reg D exemption that I mentioned earlier, because there are some restrictions to crowdfunding. One of them is the limit on the amount that each investor can put in, and also limits on the aggregate amount of the offering. And they are also, the exemption in Wisconsin at least requires that all of the investors be from one state. You have more flexibility in the Regulation D in terms of the offering amount and where the investors come from. You don't have to worry about an intermediary. There can be specific disclosure requirements, but again, if you can shoehorn within one or more of the rules of Reg D, you can get some relief from that as well. So I just want to encourage you to compare those two when you're thinking of how to look at your exemptions.
Yeah, well, thank you guys so much for coming out. I know we're right at time, but two quick things before you go. If you'll notice, each one of you had one of these cards. There's a QR code that actually contains a link to our presentation. I saw some people taking notes, so if you want to take home some notes from this, that's available through the QR code. And we obviously don't have time for group questions at this point, but if you have specific questions, hey, feel free to come talk to us one-on-one afterwards. We're happy to answer any questions you've got. Once again, thanks so much for coming out.